and welcome to Pub Case 2022 Government Contracts Annual Review. We're thrilled to have more than 3,000 session registrants for the annual review this year. We've already held 6 sessions, and 2 more will be held this afternoon following this session. We hope you'll be able to join us for most, if not all, of the remaining sessions. But a separate registration is required for each session that you want to attend, which you can do on the Pub Case site. My name is Al Schwatkin. I'm the president of the Pub Case Group and a partner in the law firm Nichols Lew. I'll be your host, facilitator, and moderator for this year's annual review. And I hope that next year we can reconvene in person. The Pub Case Group consists of 3 newsletters: Pub Case Law, Pub Case Compliance, and Pub Case Cyber. Many of you are already subscribers to one or more of these newsletters, and we very much appreciate your support. Some of you joining this annual review are not yet subscribers, but I hope you will consider becoming a subscriber. Information is at the website shown on this slide or is available from any of the contacts you have at the Pub Case Group. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on this and the next slide. I encourage you to look at the skills and capabilities that these firms have. In lieu of speaker gifts, and in honor of our sponsors, Pub Case is making a contribution to the Capital Area Food Bank. With the food crisis facing our communities, including the military, I hope you'll consider making an individual or an organizational contribution to them. Since this entire program is being held virtually, all attendees will be in listen-only mode. Your video will remain disabled throughout the session. But we do welcome your questions. Use the Q&A box at the bottom of your screen. However, with so many of the attendees joining us, it won't be possible to answer all of the questions in real time. We're capturing your questions and will endeavor to answer as many as possible after the conclusion of the annual review. All presentation slides, along with the audio, will be available for download from the Pub Case Group website, probably within a week or so of the conclusion of the annual review. We'll send you an email when this information is available for download, how to access it, and for how long the material will be available. You can also follow us on LinkedIn and bookmark our YouTube channel for additional information. We're also applying for continuing legal education in a number of jurisdictions. While we cannot guarantee approval, we expect that acceptance within the next few weeks. Again, we'll notify all attendees when those approvals have been received. Finally, if you're interested in attaining CLE, please look for our poll question during the presentation. The state boards require us to verify your participation during the event. The poll question is a simple yes/no. We'll keep track of the responses to verify that you viewed the panel. If you do not wish to obtain CLE credit, you can disregard the poll or just answer for fun. Now I'm thrilled to continue the 7th Pub Case Annual Review with our Session 7 panel on claims, disputes, and terminations. We have a distinguished panel to join us today. Let me introduce my friend Paul Corey at Wiley to start off the program and to introduce his panel. Paul, over to you.
It's a pleasure to be moderating once again this session on claims, terminations, and disputes. We've got a great panel for you. As indicated, I'll be your moderator. I'm a co-chair of the government contracts practice at Wiley. We've got on the panel Robert Nichols, who's the founding partner at Nichols Lew. We've got, Seth Locke, who is co-chair of the government contracts practice at Perkins Coie. And we've got Jamie Tabb, who is a partner at Vincent & Elkins. So what we've done this year, as we do every year, is we've divided the cases, and there are a number of interesting cases, into this year 6 different topic areas. The first is terminations, but we also will be talking about jurisdiction, timeliness, fraud, affirmative defenses, and then a catch-all sort of other important cases. So that's what we're going to get through in this session, and looking forward to it. There, as we try to do each year, we find some themes that we're going to be emphasizing. And so some of the themes that you'll see as we go through the cases, one of them is the Federal Circuit once again this year has created some mischief, possibly some confusion for contractors and for the government. Another theme that is a recurring theme that we've talked about in the past is a number of the cases involve a situation where what I would call government behaving badly. And you'll see some examples of that. Now, because we're all practitioners who represent contractors, to be fair to our government brethren, we also have a theme of some contractors behaving badly. So you'll see some examples of that too. On considerations in filing claims, and this is kind of a peeve of mine with some of my clients, one of the themes that emerges is don't wait so long. Sort of a corollary to that is don't make new law if you don't have to. So we'll be seeing some cases where that's an issue. And you're going to hear we have an extremely helpful case on what is not a false claim and on materiality. And, you know, for those of us who represent folks who deal with FCA investigations, so a really helpful case. And we're going to end on a case on contracting officer ratification, which is also, again, very, very helpful for contractors. But in any event, we're going to start with terminations. And the first case in terminations is JKB Solutions. Jamie, this is a case where the Federal Circuit did create a little confusion and mischief. So why don't you start us off with this one?
That's right. Thanks, Paul. And it's great to be here with everybody. So yeah, totally agree. This is a somewhat perplexing decision, but I'll go through the facts here really quickly to set it up. So JKB, the contractor, held an indefinite delivery, indefinite quantity IDIQ contract with the Army for instructor services. And basically what JKB was hired to do was to provide training to Army personnel on contractor management and how to create requirements packages. So basically the Army's acquisition personnel in terms of what their duties would be. And the way it was set up is it was an IDIQ contract, as I mentioned, but the Army issued 3 year-long task orders, and each task order had a price per class as well as a total price for 14 classes. And what happened was the Army ended up only needing fewer than 14 classes per year, and predictably only paid JKB for the classes that JKB actually taught, which was that lower number each year. JKB claimed that they were entitled to payment for the entire 14 class task order, total price per year, and sued for breach of contract at the Court of Federal Claims. And what the Court of Federal Claims did is determined that the government had constructively terminated the contract for convenience, relying on the fact that the contract included the commercial item termination for convenience clause, which is at FAR 52-212-4, paragraph L. The idea here was that since the government could have terminated for convenience under the clause, what they did by not ordering the full 14 classes was basically the equivalent to a termination for convenience, and therefore was a constructive termination, and JKB was only entitled to termination costs, which was, you know, the percentage of work performed and the cost resulting from the termination. So I think we can go to the next slide. JKB appealed, and the Federal Circuit actually reversed on the basis that the contract did not actually include a termination for convenience clause that could be relied on by the government for this constructive termination theory. And the reason for the holding was that the Federal Circuit determined that the commercial items termination clause that was in the contract was inapplicable because the contract was for services, and therefore the commercial items termination clause was a nullity. So this is why the decision is very confusing, because as many of you out there know, the definition of commercial items in the FAR, before it changed recently, included both products and services. So a services contract can still be a contract for commercial items. What was also confusing about this is that the underlying Court of Federal Claims decision also appeared to accept the argument that the contract was not actually a commercial item contract. But the difference between the Court of Federal Claims and the Federal Circuit was that the Court of Federal Claims determined that that was irrelevant and that the clause was still applicable. So, so really kind of confusing, but at any rate, the Federal Circuit determined that the government could not invoke the constructive termination for convenience theory, and basically sent the case back down to the Federal Circuit for an analysis of whether a different termination for convenience clause could have been incorporated into the contract through the Christian doctrine. And for those of you out there who are not familiar, Christian doctrine has nothing to do with religion. It's based on this 1960s case that basically says that certain clauses can be incorporated into a contract by operation of law if they're mandatory and express a significant or deeply ingrained strand of public procurement policy. So at any rate, we'll have to see what happens now that the case is back down at the Court of Federal Claims. But I think coincidentally, it's interesting that the FAR Council actually changed the definition of commercial items right around the time this case came out, as I mentioned before. So now the FAR discusses commercial products and commercial services rather than this commercial items concept. So I suppose going forward, we'll avoid the confusion that apparently everybody had in this case. But yeah, certainly an example of the Federal Circuit creating some confusion.
Yeah, you know, what's interesting, I mean, it looked like there was at least some attempt by JKB to argue that, hey, well, we only sell this particular course to the government, so it's not a commercial course, but of course, it's exactly of a type that they sell to commercial contractors. So yeah, it's kind of interesting to see what'll happen on remand here, because on remand, it's pretty clear that, you know, probably the commercial termination clause should apply, but certainly if not that, then maybe another one. So the next case that we're going to be talking about, Seth's going to be talking about, is one of maybe a contractor overreach. So we're being fair here, and you know, contractors doing some inappropriate things. Seth, you want to take us through Micro Technologies?
Sure. Thanks, Paul. And I'll just echo and say, yeah, this is an interesting fact pattern with a contractor acting in an interesting manner. We also are going to have an issue involving the commercial item termination clause in this one as well. So laying out the facts, here's what happened. Microtech entered into an order with Department of Justice for software licenses and software maintenance services or product. Now, the key here is that the order was for 1 base year and 2 option years. And it was at the beginning in the base year that Microtech made a business decision to purchase software maintenance for all 3 years. So it was only obligated at the beginning to provide this maintenance for the first base year, but it made, again, a business decision to purchase for all 3 years. And what happened was the base year ends, and this is where we're going to get really into the weeds of like timing, but the base year ends on a Friday. And there's no word from the government exercising anything about an option year. So now on Sunday afternoon, and the board, it's an interesting decision. It's great how the board actually gets into really the timing of all this that took place. So at 2:30 p.m. on a Sunday, a Microtech employee emailed an acquisitions person with DOJ and said, hey, we haven't heard about the option year yet. What do you want to do? And 4 hours later at 6:30 p.m. on a Sunday night, the DOJ acquisitions person responded and said, oh, we do want to extend the option. Here is a mod. Go ahead and sign bilateral mod, and it's for the full $688,000 for the annual software maintenance for option year one. Microtech signs, and they're ready to go. They believe the option year is going forward. The next morning, so that was Sunday night at 6:30 p.m. The next morning, and again, the board gets into such detail here, at 8:37 a.m., a different person in DOJ's acquisition office sends an email to Microtech and says, oops, that was an error. We never actually meant to sign up for this option year. Here is a bilateral mod to terminate the option year. Microtech refuses to sign. And so DOJ, a couple days later, issues another mod, this one unilateral, terminating the option year. And so at that point, Microtech went to DOJ and said, the way these software maintenance works is we have to actually sign up and pay for the annual software maintenance. So the second you exercise this option, we were on the hook for the full $688,000 of software maintenance for all of option year one. And they actually said in their letter, they hinted at, which means you're going to be on the hook for that. When you terminated, you might as well continue with option year one. And DOJ refused and said no. Microtech submitted a claim, and they submitted the claim as part of the termination costs and process for the full $688,000 in software maintenance. So if we go to the next slide, the CO denies the claim. And interestingly, the CO laid out some facts, but first of all, the CO said, you hadn't actually done any work between Sunday night at 6:30 p.m. and Monday at 8:37 a.m. and the purchase of the software maintenance, which you did during the base year, at the very beginning of the contract, had nothing to do with this termination. So you couldn't recover. Now, the other interesting thing in the CO's final decision, and this was relegated to a footnote in the board's decision. So my suspicion is it's a fact that because it was on summary judgment, it wasn't fleshed out. There maybe hadn't been a hearing to actually confirm this, but nevertheless, the board thought it important enough to at least include in a footnote. The CO said in the final decision, oh, and by the way, Microtech, someone in DOJ, or not even someone actually, the contracting officer's representative on Friday, when the base year ended, orally told you that we have no intention of exercising the option. Again, it's hard to tell from the decision whether that was ever confirmed, but at least the board did note that to point it out as an interesting fact. So Microtech is now at the board after the CO denied their decision. And what Microtech's argument really comes down to is it didn't matter when they purchased the software maintenance. They could have purchased it at any time, and it didn't matter that they purchased it during the base year. All that matters is that the second the government exercised option year one, the government was on the hook for the entire annual maintenance price, $688,000. Now, the government responded at the board and said, that's under the commercial item termination clause, and that's what Jamie was talking about earlier, you need to be able to show that there was a percentage of work that you did before the termination and that the costs are reasonable and related to the termination. And the government argued you couldn't do either. Well, ultimately, the board ended up siding with the government and said it really wasn't necessary for Microtech to have purchased the software maintenance during the base year for the option year. And they really couldn't, they hadn't done any work during right before the termination had occurred. And it really wasn't reasonable to tie these costs in any way to the termination. So that's where we ended up. Now, Microtech, interestingly, they've appealed to the federal circuit. So we're actually going to have another opportunity for the federal circuit to address the commercial item termination clause. But again, what we're going to see probably coming out of the federal circuit here is, on the one hand, we have Microtech making a very technical argument that no matter what, the second this option was exercised, government's on the hook for the entire year, even though we're talking no work done between Sunday night and Monday morning, versus the government seems to have a more practical argument, and an argument that at the end of the day, even under the terms of this commercial item termination clause, really nothing was done, and it's not, and none of this work was ever even related to the termination. So we'll see how the federal circuit deals with this.
All right. Okay. Well, our next topic area is going to be jurisdiction. You'll see we've got 5 cases there, two from our friend Lockheed, that neither of which turns out great for Lockheed in these. But so why don't we start? And I guess Seth, you're up first with the first Lockheed case here.
Yes, and this is, Paul, you were getting at earlier, the theme of when to submit a claim. And this is going to be one of those first cases that addresses that. And we'll get to some others later, as Paul was saying, where you maybe don't want to wait too long. Well, this is one where maybe you don't need to go so quickly and submit so early. So what happened here is Lockheed and the government had a memorandum of understanding that the Fly America Act, which requires the use of U.S. flag airlines for travel funded by the government, they had an understanding that it did not apply to indirect personnel or indirect travel. And that was actually signed in 1997. So fast forward over 20 years, and the government sends a letter to Lockheed withdrawing from the memorandum of understanding and says, all along, we got this wrong. And it turns out that the FAA and the FAR clause that implements it does apply to indirect personnel and indirect travel. And so what Lockheed did after it got that letter was it quickly submitted a claim to the contracting officer and said, wait a second, that's not right. We need an interpretation of the FAA and the FAR clause. And we need an interpretation. By the way, our interpretation is correct, that it does not apply to indirect personnel or indirect travel. And we need an interpretation now so we know what to do going forward. And the CO issued a final decision that disagreed with Lockheed and maintained the government's position that, that it does apply to indirect personnel or indirect travel. So at the board, what happened was the government brought a motion to dismiss, saying that there was no sum certain here. It's not that type of claim. And also that the particular contract at issue was not really even subject to the CDA. But the board said, we don't need to get into any of that. And we're just going to assume jurisdiction here for purposes of determining whether we have, I'll quote, live dispute. And so a live dispute exists where a disagreement clearly exists, has significant ramifications, and continues to impact the contractor. So the key here that the board looked at was the government had actually not issued any form disallowing any of Lockheed's costs yet. All they had done was withdrawn from an MOU. And really critical to this decision, there was a declaration in the record from a Lockheed executive that said that acknowledging Lockheed had not had any of their costs found unallowable. And in fact, Lockheed did not make any changes to its billing, accounting, international air transportation practices. In the end, they just hadn't done anything. And what the board said is, based on that own declaration, this really hasn't impacted the company in any way. And if the government hasn't disallowed any costs in any way, we don't see a quote live dispute here. So what the board did was it said it's going to exercise its discretion and dismiss the case, but without prejudice. And it's clear, you can tell what the board is saying is you just came a little too early. If you end up having an issue, you have costs that are disallowed, obviously come back, and when the claim is ripe, we can hear it. So again, as I was saying earlier, this can be a tough area of you want to make sure that you get claims in at the right time. You want to make sure that you know how to charge costs going forward, but sometimes early is even too early.
Yeah, so we may be talking about this case next year. But, you know, at least in this case, you know, okay, well, belt and suspenders, you came early, you can come again later. So the next Lockheed case, I would say this is an example of the question, why do you want to create new law? So Lockheed had two undefinitized contract actions to upgrade the F-16 under FMS sales, one to Singapore and the other to Korea. As you know, with these UCAs, sort of the price is left undefinitized and subject to negotiation. But if there can't be agreement, that the contracting officer retains the right to unilaterally set the price. So after years of unsuccessful negotiations, the contracting officer definitizes the price for both of the contracts at a price lower than what Lockheed Martin thought was acceptable. And so rather than filing a claim with the contracting officer saying, hey, this is what the price actually should be, and getting a final decision, Lockheed Martin appeals directly to the board, essentially saying, hey, your definitization is a contracting officer's final decision that is appealable. Now, the agency at the board said, well, wait a minute, you don't have jurisdiction because Lockheed never filed a certified claim, and case law is pretty clear that you need to do that in order for there to be jurisdiction. So it goes to the board, and there's actually a split decision there. But if you read the majority opinion, it starts out by saying, turns out we decided this case 33 years ago in a case called Bell Helicopter, where we found exactly that a definitization is an act of contract administration. It's not a contracting officer's final decision, so it's not a government claim that can be immediately brought. So Lockheed obviously knew that, and the dissent also agreed with Lockheed. Lockheed basically argued, well, two things. One, Bell Helicopter is no longer good law because there have been some intervening federal circuit cases that have changed the law and made it clear that a definitization is a government claim. And then their second argument was, hey, in any event, Bell Helicopter was wrongly decided, so you should fix that. So with respect to the first argument, there were two federal circuit cases that Lockheed Martin pointed to. The first was one called General Electric, a 1993 case that recognized that the term other relief in the definition of claim beyond just monetary relief was something that was available to argue that it was a government claim. There it was directing repair of engines, and that could be constituted a claim, and it went beyond just monetary damages. And then the second case they referred to was a federal circuit case called Todd Construction, which is a 2011 case where it was determined that the government's past performance evaluations were essentially met the definition also, and could be challenged. But the board here said, yeah, those cases don't completely undermine Bell Helicopter, number one. And then number two, on the question of whether we should just go ahead and overturn Bell because it wasn't wrongly decided, or because it was wrongly decided, they said, well, we don't have the authority to do that. Either you need the senior deciding group of the board, which I love that name, senior deciding group. Sounds like a good group to be a part of, or you need a federal circuit decision. But we can't overturn our case law like that. So once again, now, and they ended with this: we are confident Lockheed Martin has the means and the time to submit a claim before expiration of the statute of limitations. Now, once again, Lockheed Martin could have, if they went the belt and suspenders route, have submitted the claim, and this again may be one that we see again. So our next termination case, Robert, this deals with, or not termination, jurisdiction case, is the ECC case, and this deals with the some certain requirement. Can't hear you, Robert.
Thank you. This ECC case is interesting for a couple of reasons. In this case, ECC had a contract with the Army Corps of Engineers to build a military compound in Afghanistan, and they submitted a claim seeking $13 million in alleged government delays. And the claim asserted different series of delays: changes in security requirements, delayed review of designs, directive to perform additional work. But interestingly, the claim didn't break down the $13 million into different categories. Instead, it just had $13 million as a bottom line total. The Corps of Engineers denied the claim, and ECC appealed, and the government moved to dismiss for lack of jurisdiction. The government's argument here is that the claim actually asserted multiple claims for delay, each with a different set of operative facts. So each separate claim had to have a sum certain. The contractor could not just have a lump sum and have the government guess as to what the sum certain is for each element of the claim. The board ended up granting the government's motion to dismiss based on a lack of CDA jurisdiction. The board said that the jurisdictional standard for an appeal applies to each claim asserted, not to the entire case. And so jurisdiction only applies or only exists as to those claims that satisfy the CDA's requirement for a sum certain. The board then broke down what is the meaning of a claim. And it goes on to say that the term claim does not refer to the entire case submitted by a contractor. Rather, the term refers to each demand for money that is part of one divisible case. So a case involves separate claims where a contractor asserts different grounds of recovery, either factually or legally, that are distinct. And each one of those claims must state a sum certain. This takes me back many years working with my colleague, Rick Claybrook, where we were doing this massive security claim coming out of Iraq, and we ended up filing, I believe it was 135 separate claims. They were only about 2 or 3 pages each. And at the time I thought, well, this is an odd way of doing this. But of course, that's exactly what came into play here.
Yeah. Hey, one interesting reaction I had to this case, Robert, is, we see a number of claims, especially, ones in, Iraq and Afghanistan, where it's very hard to, provide detailed documentation, where people use the total cost methodology or the modified total cost methodology, which by definition says, well, I can't really specify, what had what impact, so I'm just using that. And I wonder how this case, plays into that, if at all.
So I thought about that a little bit. I think we've all been involved, especially in delay and disruption claims, where there are a series of events, ripple effects, and it's hard to nail down the precise amount attributed. In fact, it's impossible. That's why you end up with a modified total cost method or the total cost method. But in this case, what really was the defining line is that the board said the CO needs to be able to work with something. And in this case, the use of a lump sum cannot be deconstructed or allocated based on simple arithmetic. You've got to give us something to figure out what each claim arises to. That doesn't necessarily mean that there has to be arithmetic certainty with regard to each claim, but there has to be something there that the CO has the ability to identify the set of operative facts or the operative law, look at the value being asserted, and determine whether that is appropriate. And here, there was no way to use simple arithmetic to deconstruct that $13 million. And that's what doomed the contractor. So again, with your question, Paul, you can still use the modified total cost method, but you have to give the CO something to evaluate each part of the claim.
Right, makes sense. Good lesson. So the next case, safeguard base operations. This is really just an excuse to talk about a protest case in the middle of a claims panel. But so I'm going to do that anyway. Safeguard was disqualified from a competition, and it argued that it was for entirely pretextual reasons. They said one of their affiliates was the incumbent contractor, and the agency's evaluation was based on some claims that the incumbent contractor had brought against the government, and so that was part of their bid protest. And one of their issues in the bid protest, beyond attacking the reasonableness of the evaluation, was, hey, the agency breached an implied duty of good faith and fair dealing. Now, that sounds a lot like that's an implied contract theory. And so the question became, initially at the Court of Federal Claims, so can you raise an implied contractual theory? And the court went ahead and found that you could, and then on the merits found that there was no violation of the implied duty of good faith and fair dealing. Went up to the Federal Circuit, and the Federal Circuit said, this is a case of first impression. We've had a case before where we found, there's the court has two separate jurisdictional clauses that govern here. One is 28 USC 1491A1, which is the disputes jurisdiction, which includes any claim against the U.S. Upon any express or implied contract, and then B1, which is the protest jurisdiction. And the court found that they had previously in 2010 found that 1491A1 applied over implied contracts that were outside of the procurement space, for example, sale of government property, but they'd never dealt with an implied situation in the procurement context. And what they held here was that the reason this makes a difference is the standard of review in an A1 case is different from the standard of review in the protest case, where you're talking arbitrary and capricious. And what the Federal Circuit held is you can bring an implied contract theory in a protest, but it will be considered only under the B1, under the protest jurisdiction. Judge Newman dissented, basically arguing that you couldn't bring an implied in fact contract action. So anyway, there's your little protest diversion. we're gonna go back to, and this is a case where I think a jurisdictional case where I think contracting officer tried to avoid doing the hard work necessary to really figure out what to claim against some of its contractors. So, Robert, you want to take us through JLK?
Yes, I'm
Robert?
happy to.
Yeah.
And I think that this case may warrant a little bit of discussion among ourselves for a particular reason that I'll get to at the end. In this case, GSA awarded a contract to Johnson Lasky to design office space for the NLRB, and GSA hired another contractor, Master Design Build, for construction of the office space. After the space had been built out, a pipe burst, causing extensive damage. GSA issued a final decision finding that both Johnson Lasky and Master Design were jointly and severally liable for the damage. Master Design Build appealed to the board, and Johnson Lasky filed suit with the Court of Federal Claims, asking the court to vacate the final decision because the government had not attributed percentages of fault to each contractor. The government asserted a counterclaim against Johnson Lasky for breach, and the counterclaim alleged that both contractors were jointly and severally liable. The holding here is interesting. Neither party raised this issue, but the court, sua sponte, found that it lacked jurisdiction to consider claims premised on joint and several liability. Specifically, the Court of Federal Claims held that it doesn't have jurisdiction under the Tucker Act to hear, or that it has jurisdiction under the Tucker Act to hear CDA claims, but the CDA only applies to disputes involving federal procurement contracts, and a long line of cases holds that CDA jurisdiction does not encompass damages sounding in tort. Joint and several liability, the court found, applies when a tortious act is committed by several actors acting in concert. And under the doctrine, each tortfeasor is entirely responsible for the damages caused by the concerted action. The case law, including U.S. Supreme Court precedent, is overwhelmingly clear that joint and several liability is strictly a tort doctrine. And on that basis, the court said we do not have jurisdiction. They considered a couple of exceptions where joint and several liability applies to contract cases. For example, where multiple signatories sign a single contract that form a joint obligation. Each signer stands as a guarantor of the other. There's also an exception where two parties breach separate contracts, but it's impossible to segregate the damages. But the court found that these exceptions don't apply. As to the first exception, the court noted that Johnson Lasky and Master Design had signed separate contracts, so there was no joint obligation. The court declined to apply the second exception, saying that only a few jurisdictions had applied this exception, and even those courts reasoned that the doctrine was based in tort, not contract. So the fact that this underlying claim was rooted in a contract, the court found, was irrelevant. Yes, these claims arose out of a procurement contract, but the court didn't deny that. The problem was that the theory of liability asserted by the government was based in tort. As an example, the court noted that a claimant could submit a CDA claim seeking punitive damages, and that claim would arise out of contract, but the court would still not have jurisdiction to award punitive damages. So this line between tort and contract theory is often blurry, and actions resulting in a breach of contract can sometimes also constitute a tort. But the court made clear it only has jurisdiction over contract theories. If the breach is also a tort, then you need to bring that claim in a different form. Part of the reason I think that this case is interesting is that this isn't public yet, but there will, in the next couple of weeks, be a ruling with regard to unincorporated joint ventures, where you have two joint venture partners who win the contract, but they have not incorporated. So they signed separate contracts, prime contracts with the government. It's a natural case for this idea of joint and several liability to come about. Slightly different situation than what occurred in Johnson Lasky, but I see this issue of joint and several liability coming back again. And I'd love to hear from the other panelists for their comments on this court's ruling that it cannot hear this type of action where there are two contractors supposedly on the hook jointly.
Yeah.
Paul?
So I guess my reaction, I kind of started with it is here it looked to me like the contracting officer said, well, they got an expert to say, well, it could be partially this and partially that. But then rather than do the hard work of saying, okay, contractor A, you're on the hook for this, contractor B, you're on the hook for that, contractor officer just threw his or her hands up and just said, well, it's one of you guys, so you guys figure it out, or board, you figure it out. And so I think that's what was really driving the train here. I think in a scenario that you've discussed where the joint venture, has agreements, is working in concert, maybe a different outcome. But that's my take. I don't know if Seth or Jamie, you have any thoughts on that?
No, I agree with you. And I think the joint venture question, Robert, is a really interesting one. And obviously it's going to depend on the facts and how it plays out. But, if you have a joint venture where there's a clear delineation of who's going to be doing what work, kind of like what we had here, except for the fact that, as Paul pointed out, the government got a little lazy. It may not be an issue in that situation, but I could see, in a different situation. Well, I guess, yeah, because you're saying it's an unincorporated joint venture. So they are going to be separate. So you would think that there would be some type of delineation of work, much different than if you had an incorporated populated joint venture, obviously. So, yeah, I think it's an interesting question and definitely could come up as an issue there.
All right. Well, in the interest of moving things along, I'm gonna move to our next topic, which is timeliness, and we have a few cases there. And Jamie is going to start us off on the Miami-Dade case, which is one of these "don't wait so long" cases.
Exactly. So thanks. And actually, before I get into the facts here, I thought it might be helpful just to refresh everybody's recollection of the relevant law here, which is the Contract Disputes Act statute of limitations. And actually, at the bottom of the slide, we have it summarized. Basically, the idea is a claim must be submitted within 6 years of accrual. And accrual is defined in the FAR as the date when all events that fix the alleged liability of either the government or the contractor and permit assertion of the claim were known or should have been known. And for liability to be fixed, some injury must have occurred, but monetary damages need not have been incurred. So with that in mind, I'll discuss a little bit what happened here. Basically, the General Services Administration, which kind of leads all kind of real property leasing activity for the federal government, had leased office space from the Miami-Dade Aviation Department, which I'll call MDAD, for over a period of several years. And there was a provision in the lease that allowed GSA to unilaterally vacate and avoid having to pay for certain portions of the leased property. And so in 2011, GSA took advantage of that provision and told MDAD that one of its agencies would be vacating a portion of the space. But early the following year, in 2012, MDAD took a look around and decided that the agency had actually not fully vacated the space that GSA said they were going to vacate. So basically, discussions occurred over several years. MDAD tried several techniques to try to resolve the dispute and get paid, this involved invoicing GSA for the space that MDAD was asserting was allegedly still occupied. MDAD noted in lease amendments that the square footage amount was still in dispute. Eventually, the parties did reach agreement on a lease amendment moving forward that resolved the issue, but the question of payments for this allegedly occupied space looking backward had not been resolved. And so in 2020, MDAD submitted a claim to GSA for that unpaid rent. GSA denied the claim. MDAD filed an appeal at the civilian board, and the board held that the claim was untimely. As I mentioned before, this the date when the agency had claimed it was going to vacate was 2011. MDAD realized that the agency had not fully vacated by 2012, and the claim was filed in 2020. So that's 8 years later, obviously. So it's pretty straightforward analysis for the board. They determined that the claim clearly accrued at the latest in 2012. And despite the fact that the parties were negotiating and MDAD was doing all it could to resolve it over the intervening years, the claim, when it was filed 8 years later, was just outside the statute of limitations. MDAD tried a variety of arguments to try to salvage at least portions of its claim. One of them you see here in the second bullet. They argued that this should be treated as a continuing claim, which basically would have allowed the portion of the claim that fell within the 6 years, so basically from 2014 onward, to survive. But the board determined that the continuing claim doctrine was inapplicable because all of the amounts that MDAD was seeking were derived from one singular event, which was the failure of the agency to fully vacate the space. This continuing claim doctrine really is only applicable when the claim can be divided into individual distinct events or wrongs, each having its own associated damages. And the board just determined that doctrine was not at play. Also, MDAD tried to say that the statute of limitations should be equitably told. The board was not convinced because MDAD couldn't really point to any circumstance that prevented it from filing its claim earlier. So as Paul mentioned at the beginning, the lesson here is pretty clear. Just don't wait too long. Once some events occur that could create an argument that your claim accrued, keep an eye on that statute of limitations and make sure you file within the 6 years.
Makes sense. All right. So the next case I'll be discussing is the BAE case, and I'll start by saying this is one where BAE did everything right, and nonetheless, a 2019 Federal Circuit case called Hedron-Hedrat created some confusion that required BAE to deal with really a procedural sideshow that they ultimately ended up winning through no fault of their own. They still had to deal with it. So this was a contract for facilities operation and maintenance at Radford Army Ammunition Plant. An issue came up regarding payment for costs associated with some environmental issues at the plant. BAE submitted over the course of time 3 different letters that they called REAs, request for equitable adjustment. They did not request final decisions. They included the REA certifications, not the claim certifications. The contracting, the head of contracts for BAE testified, never intended for those REAs to be treated as a claim, and that we made that clear throughout. So they submit these REAs and they get a response from the CO that says this: upon consideration of your REAs, I find they have no merit to support any of the cost elements of the REAs, but we're willing to entertain reimbursement for some of those costs. Okay, so that nothing about that sounds particularly final, and it does say, hey, we're willing to talk. So BAE enters into conversations with the CO, and the CO keeps asking for more data. I need a little bit more data on this. I have one client who refers to this technique of asking for more data to sort of kick the can down the road as bring me another rock. And so anyway, BAE brings the CO another rock for a while, and finally gets fed up, and then does turn these REAs into claims. And it submits those claims, and they get a letter from the contracting officer saying, I'm not issuing a final decision yet. So they take that letter, I'm not issuing a final decision, and they go to the board on a deemed denial. So the agency, showing, I think, a little chutzpah, moves to dismiss and says, hey, when the CO issued that initial decision on the REAs, that was a final decision that should have been appealed, and they didn't appeal within the right time frame, so you have no jurisdiction. And they cited this Hedron-Hedrat case, which involved a situation where a contractor's REAs were deemed to ultimately be claims because of what happened in that case, which was, I think, pretty fact specific. But so the board dealt with this issue by saying, listen, Hedron-Hedrat did make the distinction between what's an REA and what's a claim blurry. But by contrast with what happened there, which was you had a year-long exchange of documents in a course of dealing where it became clear that the contractor was changing what it wanted. It for example, provided after the fact certification, the claim certification, and the court in that case found that it was loath to believe, after all of that exchange, that the contractor did not intend for the contracting officer to issue a final decision. So he said, to be sure, it's a closer call than it would have been before this Federal Circuit precedent, but we don't think that that this is a situation where BAE should have taken that contracting officer's decision on the REAs to be a final decision. They did make the point, however, that if it were just a question of looking at the certification, the fact that the certification was not proper is not enough to sort of protect the contractor, because that's something that can always be fixed after the fact. So in any event, this is, I guess the moral of this story is do what BAE did and document it quite clearly that you're not looking for a final decision if you're not. That ended up being the key distinction. So the next case Seth is going to talk about, this is another one where maybe you shouldn't wait, and maybe you shouldn't be forced to create new law. So Seth, you want to talk to us about triple canopy?
Yes, yeah, exactly, Paul. And, bottom line up front, the triple canopy ended up okay here, but Paul's absolutely right. This is a situation where if you don't need to wait and end up having to litigate at the board and in the Federal Circuit on a discrete procedural issue, makes sense to try to avoid that. So what happened here is triple canopy had several contracts in Afghanistan with the government providing private security services. And over the course of these several contracts, they actually had a lot of people in country. And in 2011, the government of Afghanistan issued a regulation that capped the number of employees of a private security company that could be in country at 500. And after it did that, and this is a key fact, the government, the United States government, actually submitted a letter to the Minister of the Interior of Afghanistan saying, well, we need Triple Canopy here. We have contracts with them, and they need to have more than 500 employees here. They need an exemption. They didn't hear anything back. And in March 2011, the government in Afghanistan then issued another regulation saying, okay, not only are you capped at 500, but if you go above 500, we're going to issue penalties for every single employee over 500. And so that's what happened here with Triple Canopy. They received from the government of Afghanistan in March 2011 a letter that imposed a penalty on them. But in the same letter imposing the penalty, the government of Afghanistan said, if you object to this penalty, please submit your objection and we'll consider it. So that's exactly what Triple Canopy did. And while that letter was submitted, again, the United States government again went to Afghanistan and said, hey, we need an exemption. Triple Canopy needs an exemption here. They need to have more than 500 employees. Fast forward, the government of Afghanistan considers Triple Canopy's appeal, we'll call it, for a few months. So it was originally, the government of Afghanistan had issued the penalty in March 2011. Then they received the appeal. Well, then they rejected Triple Canopy's appeal in July 2011. So at that point, in July 2011, Triple Canopy now knew that they were on the hook for this penalty. The case doesn't explain what led to the delay, but fast forward 5 years and 9 months, 10 months, 11 months, almost 6 years, Triple Canopy finally submits a claim to the contracting officer in June 2017. And their claim was on the foreign tax clause in the FAR. And what they said is that our price should be adjusted for the penalty we had to pay the government of Afghanistan. So we want to go to the next slide. The government didn't issue a decision. It was deemed denied, and Triple Canopy appealed to the board. And what the board said is that this is untimely because you knew as soon as you got your letter in March 2011 that you were on the hook for this penalty of having to pay the government of Afghanistan. And under the FAR clause, that's when you knew that you wanted to that you would need a contract price adjustment. So you had to submit your claim within 6 years of March 2011, which is March 2017. Submitting your claim in June 2017 is too late. So Triple Canopy appealed to the Federal Circuit, and the Federal Circuit disagreed. And it all came down to a line in the foreign tax clause. And the line in the foreign tax clause in the FAR is that the contractor must take, quote, all reasonable action to obtain exemption from or refund of any taxes or duties. And what the government had argued was that may be there, but that doesn't rise to a level of a pre-claim mandatory procedure, that you have to do something before you submit your claim. And the Federal Circuit disagreed. And the Federal Circuit said that language clearly says that Triple Canopy had to object or appeal to the government of Afghanistan before it could submit its claim. So what does that mean in practical aspects? When they received the penalty from Afghanistan in March 2011, they couldn't have even submitted a claim at that point. They had to follow a pre-claim mandatory procedure of seeking an appeal with the government of Afghanistan. And it wasn't until that appeal was denied in July that the claim actually accrued. And so that's how the Federal Circuit said their claim in June 2017 was actually timely. Now, one other interesting thing I'll just say at the end here also is at the Federal Circuit, one of the things the government argued was, well, it was entirely, it wasn't even necessary to have submitted an exemption because at the time, the government of Afghanistan's regulation was clear. They could not get an exemption. They had to pay because they were over 500 employees. And what the Federal Circuit said to the government was, that's a really ridiculous argument that the government's making, borderline disingenuous, because you government actually tried to get them an exemption. So how can you now tell us that an exemption was impossible? So that was just something that I wanted to point out the Federal Circuit mentioned at the end there. So now it's actually on remand and getting to the merits of, was this something that could even be recovered, these costs, under the foreign tax clause? But again, it's going to the theme that, Paul, Jamie, others have talked about already. They waited until the very last minute, June 2017, when it accrued, when the statute of limitations were to run in July. There is no at least from what we can tell in this case, there didn't seem to be a reason why they had to wait that long. It would have been good practice and safer and avoiding having to litigate all the way to the Federal Circuit if you just maybe submitted several months earlier. So that's, again, something to consider as you're putting together claims and thinking about timing.
Right. And I think it, gets back to what Jamie said about, once you have a problem, that's when you ought to think of as the start date for the 6 years. So Jamie, speaking of that, we've got another timeliness case, BNN. Do you want to walk us through that? Yep.
Yeah, definitely. And this case, I think, is useful because it helps illustrate the kind of various ins and outs of the accrual concept when we're talking about statute of limitations and when the claim accrues. So another Afghanistan case, BNN, the contractor, held a multiple award IDIQ contract with the Army to deliver cargo, including fuel, to various locations in Afghanistan. And basically, for those who don't know, the multiple award IDIQ contract, all it means is there were other contractors that had the same contract, so the Army could pick and choose which contractor would order these delivery services from. And there were various mechanisms in the contract to kind of hold the contractors to, or to incentivize the contractors to deliver and to have high quality performance. And basically what the way these worked is the Army could take invoice deductions for failure to meet certain metrics in a quality assurance surveillance plan, or QASP. There was also a provision that said that if the contractor's truck arrived at the destination and to deliver fuel and more than 5% of the fuel was missing, the contractor wouldn't get paid for that trip at all. And there's a separate mechanism, it's not described on the slide, but it's called the Order of Merit List, or the OML. And basically the way it worked is the Army would rank the various contractors based on how they had performed in any given week, and then would assign the following week's work based on that ranking. So the better you did in 1 week, the more work you would get the following week. And so the Army ended up applying several deductions based on alleged failures of performance by BNN, mostly relating to the quality assurance surveillance plan that I mentioned earlier. There also were some instances where they said there was a pilferage of fuel, and the Army began withholding those deductions when it paid BNN's invoices. Again, like Seth mentioned, I'm not sure what the delay was, but years passed, and then BNN filed claims for the withheld amounts, which the Army denied. BNN then appealed, and the Army moved for summary judgment on timeliness grounds. And the disagreement here on the statute of limitations was that BNN was arguing that the claims accrued when the Army actually did not pay the full amount of the invoices, whereas the Army was arguing, no, the claims accrued when we told you that we were going to take those deductions. And is also kind of similar to Seth's case. This was just a period of months that would have made the difference between one side winning and the other. I think the Army informed the contractor that it would be taking the deductions, you know, like in March or something like that, and by October or November, it is when the date when the invoices actually were paid and the deductions were withheld. So the board sided with the Army, granted the summary judgment motion on timeliness, and the decision basically said, look, your claim accrued when the Army told you that they were going to be taking these deductions. As we mentioned when we talked about the definition of accrual, monetary damages need not have occurred or been incurred at that point in time. Just some injury had to have happened. And so it's when BNN actually learned that the Army was taking this position that the claim accrued. So, you know, one interesting thing about this case, I think, is that the board actually reached a different result on an argument, a separate claim that BNN had relating to that order of merit list that I talked about before. Even though the missions, the argument there was BNN was saying that the OML calculation was incorrect and it should have received more work than it actually received during performance. And the missions that were at issue there actually did take place more than 6 years before the claim was filed. But the board determined that BNN did not have in its possession the information it needed in order to realize that it had a claim until several years later. And so that gets to the known or should have known aspect of the accrual definition that we talked about before. So I think this just goes to show it's all very fact dependent, in terms of whether a claim accrued at a certain period of time. But again, the lesson is if you know you have an issue, we'll start that clock and make sure you file within the 6 years.
Good advice. Good advice. All right, we're moving to our next topic, which is fraud. And the first case, this United States ex rel Howard v. Cadell, is a case I was referring to at the start. It's really helpful case on what isn't a False Claims Act claim. And so, Seth, you want to walk us through this one?
Yes, as Paul said, it is a very, very helpful case. The judge in this case walked through and explained a lot of the elements of the False Claims Act, and specific to when a prime contractor has to be dealing with a subcontractor, and the subcontractor may have behaved badly in putting itself out there as a small business subcontractor. So really, really helpful case. The facts here, there's a lot to unpack, but the facts here are that there was a False Claims Act action brought against Prime Contractor, which was a joint venture made up of Cadell and Yates, two construction companies. And they had a $180 million about contract to build like barracks at Camp Lejeune for some Marines. And the relator, this was brought by a relator, they brought a sealed case in 2011. That was when the contract performance was still ongoing, and it was unsealed in 2014. The government did not intervene against the prime contractor joint venture. It did intervene against some other parties in order to initiate settlement with them. But the key is it did not intervene against the prime contractors. And another key fact here is actually the relationship between the government and the prime contractors. As I said, the contract was in the 2008 or 9 to 2012 timeframe. That's when most of the performance was done. And then there was a little bit of like punch work and other things after 2012. But, and again, the case was filed in 2011, and the government, so the government knew about it at that point. The government chose not to intervene against the prime contractors. The government also continued to issue contract awards, other construction projects, to each of the construction companies after 2011. And the court found that also to be a critical point. So going through what the actual allegations here was that there was a subcontractor, Pompano, that was going to be providing masonry work. And the prime contractor realized that it needed to actually up its small business subcontractors in order to meet its small business subcontracting plan. So Pompano's owner came up with the idea of creating a small business, a woman-owned small business contractor called Breslow Construction. And it would be Breslow Construction that would sign the subcontract with the prime here. And then the work would flow through Breslow to Pompano, a large business. And the idea was that that way, the prime contractor could take advantage of the small business work towards its small business subcontracting plan. And again, key facts here is that Breslow Construction hired a law firm, and the law firm prepared all the small business documentation. The prime contractor said, we want to make sure we deal with you correctly, so please put us in contact directly with your law firm. The law firm represented that everything was up and up, that they were a legitimate small business, and the small business provided a self-certification that it was in fact a small business. Turns out it wasn't, as the slide says here, it was a sham small business. And so that's what the relator brought an argument, brought a case about, was that the prime contractor here, every time it submitted a small business subcontracting plan, they were called individual subcontracting reports, where it said it was in compliance with the subcontracting requirements, that it was submitting a false claim. The relator also argued that there was a certification in the monthly progress report request for payments that said that the prime contractor was operating in accordance and certifying that it was operating in accordance with all contract terms and conditions. And part of the contract terms or conditions was attempting to meet the subcontract plan. And so the relator said those were also false claims. Well, what ended up happening was the court ended up saying, no, this is not a False Claims Act case, or this doesn't rise to level of False Claims Act liability. And it went through, like I said, a number of the elements of the False Claims Act. So first, the court said an individual subcontractor report, an ISR. This is not a claim for payment. Worst case scenario, you submit an ISR that's not accurate, the government will reject it, but the government will continue letting you perform and do the work. So it really isn't a claim for payment. So the next thing that the court did was it looked at, was there either an express false certification or an implied false certification? And on the express, it said, okay, yes, there's a certification on the request for payments separate from the individual subcontractor reports, but that certification was not expressly saying that they were complying with their small business subcontracting goals. So then the court looked at a potential implied false certification. And there, the court went through a number of reasons, very helpful for contractors going forward, about why this is not an implied false certification. First, the court said that the government did not identify compliance with the subcontracting plan as a condition of payment. Next, they said that the subcontracting plan and the ISRs submitted and evaluated separately from a request for payment. They had nothing to do with a request for payment. Then again, like I said, they said that the certification in the ISR is about accuracy. The government's going to continue doing work here, even if you don't meet your subcontracting goals. And then fourth, the court said, we got to look at the history here of what's going on. The government obviously knew about these potential False Claims Act issues and nevertheless continued working with this company. And then next, they went through and said that there was evidence here that the prime contractor really didn't know that compliance with a subcontracting plan was going to be material to the government. So going through all those elements, the court said there can't be an implied false certification. There's no materiality. And that's been an issue for contractors trying to determine what's material and what isn't. And those 5 things here very helpfully lay out, okay, why there couldn't be materiality here. The court then also said that there couldn't be scienter either because they, prime contractor, relied on the subcontractor's self-certification that they were a small business. So the prime contractor did not knowingly submit anything false. So then the last thing, again, I'll just add is the relator was trying to throw everything possible against the wall. So they also brought an Anti-Kickback Act action against the prime contractors here and said that you were paying a kickback to Breslow Construction, that the work would then be passed through. You were just giving them like a 1 or 2% kickback for the work. And the court said, first of all, no, that for all the reasons we just discussed, it's not an Anti-Kickback Act violation. But in any case, relators cannot maintain Anti-Kickback Act actions. A relator can bring a False Claims Act, that's allowed under the statute, but the Anti-Kickback Act is reserved for an action by the government. So I know there was a lot to unpack there, but really, key takeaways: small business compliance with small business subcontracting plans, not material to the government under these facts. And really, they're not claims for payment. And so again, very helpful analysis for contractors to figure out what's materiality, what the requirements are to actually meet a False Claims Act action.
Thanks, Seth. For those of you who defend contractors in FCA contexts, this case alone is worth the price of admission to the Pub K Law session today. So next case, and this is one again, Robert, where I think contracting officer might have tried to avoid doing some hard work here. This is the Nauset Construction case.
Yeah, thanks, Paul. Actually, before we leave Cadell, I think the holding, you're right, is helpful to contractors, but I'm not sure how many of us practitioners would advise our clients to proceed in the way that the contractor did there and hope that the court finds it not material. I think that was fairly risky business, and but we do have a good decision to go from here.
Right. Well, obviously, if anybody had known that, if anybody at the prime had known that this was a sham, that would be clear. Okay, yeah. Let's turn to Nauset. Yeah.
So Nauset Construction had a contract with the National Guard Bureau to build a unit training equipment site. Nauset submitted a claim for $2.5 million. But the contracting officer kept kicking the can down the road in refusing to give a final ruling, contending that there were ongoing investigations into Nauset by multiple agencies. The agency ended up terminating the contract for cause in November 7, 2017, leading Nauset to file a second claim challenging the termination and seeking payment for completed work. The contracting officer sent a letter to Nauset regarding its 2 claims. The letter stated that based on investigations conducted by the Army and DCMA, she suspected that Nauset's claims were fraudulent. Therefore, under FAR 33.210, she lacked authority to take any additional action. Nauset appealed, and the government moved to dismiss, arguing that because the claims involved fraud, the board lacked jurisdiction over the appeal. The Army also argued that the appeal of the termination had been timely filed more than 90 days before the termination, so that appeal was untimely. The board declined to dismiss the appeal of the monetary claim, but it did dismiss the second claim challenging the termination. In refusing to dismiss the monetary claim, the board made a distinction between those claims involving fraud versus those claims where the CO merely suspected fraud. The board seized on the fact that FAR 33.210 states that a contracting officer lacks authority to decide, quote, any claim involving fraud, unquote. But in this case, the contracting officer's letter to NASET stated only that she suspected fraud. And this is an important distinction. To involve fraud means to include something as a necessary result, whereas to suspect fraud means to have an impression of something without certain proof. So going to the dictionary for that and applying it against 33.210, the board said that suspicion of a fraudulent claim, absent something more, will not negate the board's jurisdiction. Here, the contracting officer suspected fraud, but then made the unwarranted inference that her own suspicion of fraud meant the case involved fraud. And that was not enough to deprive the court or the board of jurisdiction. The government came back and argued, well, these are under investigation for fraud, therefore they necessarily involve the possibility of fraud. And the board rejected this argument as well. Just because NASET was being investigated did not mean that their claims actually involved fraud. What's more, even if some other agency did end up making a finding of fraud, it wouldn't deprive the court or the board of its jurisdiction here, because the board possesses jurisdiction so long as the board itself does not have to make the final determination. I'll hit on that second claim very briefly in terms of whether they were timely in submitting that second claim for trying to reverse the default termination. What's interesting about this here is that the contractor had put in their second claim, but then the government didn't actually take action on that, or they took action on it, but the contractor asked for reconsideration of that action. And that ended up not going the way that they wanted here, the government wanted. So the bottom line from this case is that a claim may smell a little rotten, but there has to be more than a mere whiff of fraud to negate the board's jurisdiction. Paul?
Makes sense. Yeah. I suspect fraud is not enough to get you out of addressing the issue. So in order to be fair, the next case, which I'll discuss, Hollymatic, involves a contractor behaving badly. So this is a defense commissary agency, DECA, procurement for meat grinders. And although this is apropos of nothing at all, I was intrigued by the stated purpose in the solicitation for the procurement: to acquire a mixer/grinder to thoroughly mix and blend lean and fatty meat products for further processing into other products. And as a guy who likes to make really good hamburgers, I know that, you use a little chuck, which is fatty, and a little prime, which is lean, and you put it together and it makes a really, really good burger. And I was pretty impressed with the sophisticated culinary purpose here that the DECA had. Anyway, that's an aside. So it's a FAR Part 12 commercial item solicitation for these meat grinders, and there were 3 requirements. First, there had to be 2 motors, one for the mixer and one for the grinder. And then there had to be 2 different certifications: the Underwriters Laboratory certification, UL certification, and a National Sanitation Foundation certification, NSF certification. So Hollymatic submitted its initial proposal, and it proposed its model 180A. And the government looked at that and said, "Hey, you only have one motor here. So this proposed, and oh, by the way, that solicitation also said, hey, our 180A is UL certified and it's NSF certified, which was true. So the government says, yeah, this proposal is unacceptable. You only have one motor. So in response, Hollymatic says, oh, no, we have the 180A option, which has a dual motor option. That's what we're going to be giving you. So the government asked some questions, and you know, they are found acceptable and ultimately win the contract. Now, what Hollymatic didn't tell the government is they had never made a dual motor 180A ever before. They still hadn't at the time of proposal. They certainly hadn't gotten a dual motor 180A certified either by UL or NSF, and had no intention of even trying to do that until and unless they actually received award. Ultimately, the government decided once they learned about this. Now, ultimately, after they got award, Hollymatic started the process, but the government decided they really hadn't gotten what they anticipated they would, and terminated the contract for default. And they also, in addition to that, asserted a government claim. We want you to pay us back all of the money that we've already paid you. So Hollymatic appeals the termination for default, and the government, in responding to that, raises an affirmative defense of fraud in the inducement. You fraudulently asserted that you met all these requirements when you didn't. So the board agreed that Hollymatic had obtained the contract through a fraudulent misrepresentation. They started by saying, and this gets to what Robert was talking about in terms of a finding of fraud. We can't. Typically, what the board will do is look to see if another court of competent jurisdiction has found fraud, and then they can rely on that. In the absence of that, they are allowed to look at whether or not the contractor made misrepresentations. And here, they found that Hollymatic, at best, had told half-truths, which amounted to misrepresentations. And that they defined half-truths as something that is true with respect to the facts stated, but failed to include qualifying matter necessary to prevent implication of an assertion that is false. And here, what they said is, yeah, it's true that your initial 180A was certified, but that was only with respect to a one motor solution, not a two motor solution. And that was the implication. So what they ended up doing is finding the contract void ab initio. It was based on a fraudulent misrepresentation. Now that had some interesting consequences. Given that the contract was void ab initio, the board obviously lacked jurisdiction to hear the termination for default challenge, but it also lacked jurisdiction to hear the government's claim for repayment of the separate amounts. The unsaid is, hey, if you want to recover that, you're going to have to go file an FCA claim against the contractor. So anyway, we ended with the fraud section with the contractor behaving badly. Our next section is affirmative defenses. And here's a Lockheed case, and this is one that they win, Jamie. So why don't you walk us through this affirmative defense?
Right. Yeah, thanks. And this case is, I think, useful in that it's kind of a rare case that provides contractors and practitioners with a really easy to understand bright line holding. that can be applied going forward, unlike some of these other issues we've been discussing where it's clear there are lots of ins and outs and it's all very fact dependent. So, so Lockheed held a contract with the Air Force to upgrade some aircraft, ended up having to do a lot more work than it anticipated and submitted a claim for $143 million. And the Air Force denied the claim and Lockheed appealed. And at the board, the Air Force asserted an affirmative defense of latches, arguing that Lockheed had unreasonably delayed in asserting its claim. And just as a refresher, latches is an equitable doctrine that basically protects defendants from plaintiffs that unreasonably and prejudicially delay in bringing their claims or lawsuits. So Lockheed moved for summary judgment to basically focused on this latches defense to try to get that defense just off the table in terms of the litigation. And the reason was Lockheed pointed out, we filed our claim within the CDA's 6-year statute of limitations, which we had discussed a few minutes ago. And the board agreed with Lockheed. I think we can go to the next slide here. Basically, the board looked to Supreme Court precedent and determined that the latches defense is unavailable when there is a legislatively enacted statute of limitations. And since Lockheed had brought its claim within the 6-year period, the government really could not try to use latches as a way to get rid of the claim or as a bar to Lockheed's claim. The Supreme Court case was a 2017 case called SCA Hygiene Products. And it was not, that case was not a Contract Disputes Act case, it was brought under the Patent Act, but the board found that the Supreme Court's discussion was sufficiently clear and sufficiently broad that it should apply the ruling to the CDA context. And I thought it would just be helpful, I'll kind of read here what the Supreme Court said. It said, the enactment of a statute of limitations necessarily reflects a congressional decision that the timeliness of covered claims is better judged on the basis of a generally hard and fast rule, rather than the sort of case-specific judicial determination that occurs when a latches defense is asserted. Therefore, applying latches within a limitations period specified by Congress would give judges a legislation overriding role that is beyond the judiciary's power. So it's really a kind of a clear-cut separation of powers issue. And you know, the board acknowledged that the Federal Circuit had not yet addressed this issue of whether latches is still available as an affirmative defense in light of the Supreme Court case, but the board determined that they didn't need to wait for the Federal Circuit to opine. It was sufficiently clear from the Supreme Court's 2017 decision that latches is just no longer available in these circumstances when there is a clear statute of limitations and the claim is brought within that statute of limitations period. So again, nice bright line rule for all of us to understand going forward. And actually, I noticed there was a subsequent case to this Lockheed case where the board, also ASBCA, made the same decision with respect to a government claim. So it went the other direction. So this is not just applicable to contractor claims.
All righty. Good to have a nice clear rule. So the next case, WEC, and I'll deal with this relatively quickly because I think we want to make sure we get through all of our cases. So this is one where the message is pretty clear, and WEC did this very well. Be careful about reserving your rights. So this is a contract for to renovate the Langley Air Force Base Exchange. Shortly after getting started, there are all sorts of unexpected site conditions, and the government works with WEC to modify the contract to address some of their immediate costs associated with dealing with the unexpected site conditions. Throughout their discussions, WEC reserves its right to go after extended overhead caused by the delays, but in the interim, agrees to mods that deal with some of the more immediate direct costs. Now, each of those mods had some language about fully settling all entitlements arising from the changes. And ultimately, just as it indicated it would, WEC sought subsequently to recover its extended overhead costs. And the government said, nope, sorry, that's barred by the doctrine of accord and satisfaction. You signed these mods that say you fully settled all entitlements arising from the changes. So too bad, so sorry. The board didn't buy that. It looked at the communications that were incorporated into the modifications that established that everybody understood that overhead costs would be deferred until later. And so those costs were not encompassed in the full settlement language. And, they also noted that subsequent to those mods, the government entered into negotiations with WEC to talk about the extended overhead, suggesting that they recognized that there was entitlement there. And that kind of activity prevents you from making an accord and satisfaction argument. So helpful to the contractor. So the next case, Robert, I think is one that we could call another contractor behaving badly case. Why don't you take the Brantley Construction Services for us?
Yeah, this is an interesting one, in large part because of admissions made by the CEO of the contractor during the hearing. In a nutshell, the Army Corps of Engineers issued an RFP for the replacement of 2 concrete aircraft taxiways at different locations. And the RFP said that contractors could use either of 2 types of concrete placement, fixed form concrete or slip form concrete. For those of you who've been around construction a long time, this is a lovely set of facts. The fixed form concrete involves the use of ready mixed concrete hauled in a mixer truck. But the RFP said that if the contractor chose the fixed form method, the concrete had to be deposited within 90 minutes of mixing. So what that means is you need to know where your concrete mixing is going to occur. The slip form method of concrete is that the concrete is mixed at a stationary plant and then transported in a non-agitating truck, meaning a truck that's not continuously moving, that allows the concrete to harden. And if the contractor chose that form of concrete, then it had to make sure that it had the ability to get to concrete into place within 15 minutes of mixing. Brantley Construction, interestingly, they put in a bid, but they did not accept the agency's invitation for a site visit to the bid. Rather, they put out to subcontractors to get bids from subcontractors as to what it would cost for them to place this concrete. But in putting out for the bids, Brantley Construction did not specify the method of concrete placement or location. And so it was at a bit of a disadvantage in that it put in a bid, but it had no clear method as to how it was actually going to perform. Well, of course, it gets onto the contract and it finds that it can't actually do either. It can't do the fixed form method and get concrete, they say, within 90 minutes of mixing, or within 15 minutes for the slip form contract. But what's interesting about this is that they claim that the specifications themselves are defective because you assume that you can either get it there within 15 or 90 minutes. But the board would actually not have anything to do with that. They argued that, you know, potentially the specification was in error, but Brantley here didn't actually rely on the specification because they did not go in and pick a plan to perform this concrete installation, and therefore it could not say there was an ambiguity that we relied on and use that as an excuse. Also, they claimed that it was impossible to actually achieve what the government sought to do with the 15-minute time frame for slip form. But again, the government was having none of that. It stated, or the board stated that it's unclear whether it was impossible because Brantley never actually tried to do that. So the key takeaway here is that if you're going to claim a defect in the specifications, either an ambiguity or an impossibility, you have to show that you actually read and understood the RFP, and your reliance on that ambiguity or impossibility was the problem. Here, the CEO actually testified that he had not done the site visit, but he also had not really even been aware of these timeframes. And that testimony, I think, is what did him in here in terms of enabling this affirmative defense. Paul?
Yep, thanks. Yeah, makes sense. Yeah, you can't say, hey, these are confusing specs if you didn't bother to read them or try to figure out how you're going to comply. So we're about to get to other important cases. I think, Bill, we have about 5 more minutes left, but correct me if I'm wrong on that. So let's, each of these cases involves the government behaving badly. But so let's start with Ology, which Seth, you wanna take us through?
Yes, thanks, Paul. And this one, this one comes down to whether it was appropriate for the government to apply penalties for the contractor because of what the government claimed were, quote, expressly unallowable costs. So what happened here was Ology had submitted its indirect cost rate proposal for fiscal year 2013, and in it, it had included the costs for its executive compensation for its CEO. At the time, they actually exceeded the cap that was in place for 2012. So that's what this issue really comes down to, is the government had issued a cap on executive compensation for fiscal year 2012. But then when fiscal year 2013 comes around, they didn't issue the cap on executive compensation for several years after that. It wasn't until 2016. And so there was this period in time in fiscal year 2013 where contractors didn't know what the fiscal year 2013 cap was. And so when Ology submitted its indirect cost rate proposal, they didn't have any guidance, or the government hadn't said, okay, here is what the cap should be. And so, when they went over it, the government issued a final decision years later saying, well, we're going to go ahead and apply that 2013 cap, even though you didn't know about it, and we're going to apply penalties to you. And what Ology argued at the board was, okay, we acknowledge that the costs were unallowable and that we can't recover beyond that 2013 cap. However, it's inappropriate to apply a penalty to us. And the penalty was large. It was approximately $980,000. And it's inappropriate to apply that penalty on us when there was no cap in place at the time. And so the government then switched and said, well, there was a cap from earlier years, 2012, that clearly applied going forward. And the board disagreed and said, no, for purposes of meeting your burden of showing that these are expressly unallowable costs, it's not fair to just assume that the 2012 cap applied to subsequent years. And in fact, it shouldn't, because you're supposed to issue a new cap each year. So key takeaway here, if you're hit with a claim that includes expressly unallowable costs, remember, it's the government's burden to prove those, and take a close hard look at whether it makes sense to appeal, maybe not the unallowable portion, but at least the expressly unallowable penalty. Go on to the next one if you want.
Okay, so next one, Pacton Construction, Jamie.
Right. So this one is an interesting case. Involves the question of when a foreign contractor can assert a takings claim against the United States for a alleged taking that occurs outside of the United States. So Pacton was an Afghan company, had a long history of supporting the United States and Afghanistan, both as a subcontractor and a prime contractor. On the particular contract at issue here, Pacton was working as a subcontractor on a construction project. There was a work site where it had to bring a lot of equipment. And at one point during performance, the Army ordered the prime contractor to stop work. Pacton was instructed to vacate the premises, and the Army would not allow Pacton to retrieve its equipment. As Paul said, this is another case of the government behaving badly. The case goes through a series of events where Pacton tries to get access to its equipment through various means. At one point, they actually approach the work site and they're told to go away, to never ask about their equipment again, and they were actually threatened with arrest. So at any rate, Pacton later files a Fifth Amendment takings claim, a lawsuit in 2019. And so there are kind of two issues that were dealt with by the Court of Federal Claims here. One was whether Pacton, as a foreign company, had standing to even bring this claim, and then there was also a timeliness question. So on the standing issue, the court looked to whether Pacton had substantial connections to the United States. And this was a test that the court derived from a 2008 Federal Circuit case that also dealt with takings involving a foreign contractor. And what really saved the day for Pacton here was that they could show that they had connections relating to prior work, both as a prime contractor, as I said, and as a subcontractor. They had received various letters of recommendation, letters of commendation from US government customers. So they had connections to the US government beyond the actual subcontract that was at issue here. And on the timeliness issue, the court applied, we're not in the CDA here because this is a takings claim and not a contract dispute, but the court applied the 6-year statute of limitations under the Tucker Act, which is also applicable to Fifth Amendment taking claims brought at the Court of Federal Claims. And even though Pacton was aware that the US government was kind of blocking access to its equipment more than 6 years before the claim was brought, the court applied what they called an accrual suspension rule and said that Pacton really was not on notice that its claim had accrued until it saw Afghan Army officers actually using its equipment. So my sense is this may have been a situation where the court kind of gave the contractor a break on the timeliness issue, just given how badly it had been treated. But anyway, I'll stop there because I know we're running out of time.
All right, no, thanks, Jamie. So we're going to end with, and I had promised a good ratification, contracting officer ratification case, and Robert's gonna tell us about Force 3.
Paul, this will be quick. Here, HHS awarded a delivery order for software, and the delivery order had 1 base year period and 2 option year periods. Government exercised the first option year period, but declined to exercise the second option year period. But the contractor noticed that HHS was still continuing to use its software in that 3rd year, even though it hadn't exercised the option. So they brought a claim. The government's response to this, I think, is classic. it contends that it was up to the contractor to disable the software, not up to the government to just simply stop using it. They said, as long as we have it, you haven't disabled it, we can continue to use it, even though we didn't exercise the option, we're not paying for it. The board agreed that the agency had not exercised the option. The contractor argued they had constructively exercised the option by continuing to use the software, but the board said, no, to exercise an option, you have to actually strictly comply with the contract terms for exercising it, and they didn't do that. But then the board goes on to say, instead of exercising the option, essentially the CO ratified a commitment to use that software services by actually knowing, or even impliedly knowing, that the agency was continuing to use that software. The CO essentially ratified that commitment, even though an option wasn't exercised, and therefore the government is liable for paying for the software services that it knew that it was receiving without paying for. I'll stop there.
All right, thanks. Yeah, it's hard to find a good case where the contracting officer actually ratified something and the courts hold that. So, or the boards hold that. And so this was a good case. Well, with that, I want to thank our panel. We've enjoyed this.